So MZM as a firm, over the years we've specialized in white collar crime. When in 2005, when we set up the firm, at that point of time, the clarity for us was to be involved in criminal law, because that was the core expertise growing up. That is what I learned with my father, and that is exactly what was the core subject that we started with. As time passed by, we realized the magnitude of the cases, the magnitude of the scams that were happening, the relationships that were built through the firm, and the networking that was made, the kind of people that joined us and started working with us. We realized that this niche area, which was being developed over the years, called white collar crime or business crime defense, took center stage. So essentially, when you say key practice areas, white collar crime entails a lot of advisory in relation to our domain expertise as far as white collar crime is concerned. It could be corporates, it could be banks, it could be multinationals, it could be HNIs who probably are facing some kind of an investigation. So it could just be restrained to a particular broad-based advice as to what are their rights, what are their duties, what are the things that they should not do or should do, and basically preparing a SWOT analysis. So our practice area is mainly advisory, and all those clients and companies and corporations who are interested to hire us, then we have the entire end-to-end practice area, which entails generating a complaint or maybe getting a bail or an anticipatory bail and advising them to the entire criminal trial process. So that's a very good question, and there's a thin line, though. Actually, white collar crime is a part of the entire criminal law practice. The laws are not really different, but there are certain. The only difference is when you say criminal law is wider. The gamut is huge. It also involves petty crimes. It also involves blood crime like rape and murder. It involves dacoity. It involves various other things. White collar crime is that particular section of criminal law which particularly focuses on economic offenses and offenses which are by corporations, bankers, officials, people in responsibility, which is exactly how it's termed as white collar, because these are educated, intelligent, successful people who are sitting in position of power and responsibility, and in some way misusing that power and responsibility for certain wrongful gains, thereby causing wrongful losses either to parties or to the state. So that is basically economic offenses or white collar crime. These are complicated offenses. These are extremely complex crimes. There are specialized agencies that investigate these offenses. So it's not your simple a criminal matter which has happened, maybe a small theft or a simple hurt or an assault, which can be investigated by the local police station. So these are complex, extremely complicated offenses, and that's why they are termed as white collar crime. So, as a domain expert and as an expert in this field, that's the position that we've enjoyed now for the last 5 or 7 years continuously. We've been representing both the sides. We have represented complainants who are aggrieved. We have represented banks who are aggrieved. We have represented persons accused of mismanagement or of embezzlement or of have generated wrongful gains, thereby causing wrongful losses to the party. So we've been for accused persons and we've been for complainants as well, both the sides. We've been representing NBFCs, we've been representing banks, representing companies, lenders, large institutes, educational institutes. So anybody who has had a brush with fraud, it could be a cyber fraud, it could be a financial fraud, data theft, all of that. So we have all forms of clients. I mean, we represent real estate magnates, we represent agrochemical companies, we represent corporations. So it's all forms. So as I mentioned, we entire end to end. We provide assistance to clients from an end to end basis. Either it's a complainant, so it's inception of filing a criminal complaint. The aggrieved party walks into our office and says that I have suffered XYZ and I need to take legal action. From that point till taking him to the entire trial. Similarly, for the accused, from the time a case has been slapped on them, there is an FIR registered, whether it is in local Bombay or Delhi or maybe some city somewhere else. We, from advising them from what their rights are, what their duties are, what are the facilities that they can avail, what are the options that they have, advising them to actually executing the entire process. So we advise all throughout and we handhold the client till the end. But there are stages where clients can come. Most of the time, people don't come to us at an inception stage. So when things happen, usual tendency of a party is that they will speak to somebody in the family, they will speak to someone who they know each other, or some general lawyer who may be a lawyer who drafts wills, who would advise on criminal law. That's the biggest mistake what people do. And when they come to us, we realize that we ask them all the questions, and then it's most of the time we realize that we have to undo so much that has already been done. And that is the tough part. So what happens is that whenever the client comes at that point of time, we need to start from there. So sometimes when the client or the client's relative, the accused person, is arrested, and we step in at the time when bail applications have already been filed, and then our expertise is required to argue the bail only. And then there is so much that we can't, there's only so much that we can do because the petitions are already filed. You can't change that. I mean, then you'll have to do, there's a humongous amount of work to change all that. So it depends. But as I said, that we provide all throughout the service end to end. So wherever and whatever situation the client realizes that I should come and knock the door of a competent firm, that is the time when we step in and we do our best. So let's put it as an average, an average day for a lawyer who's practicing in the white collar. Not me per se, because I think as a managing partner of the firm, you have multiple other responsibilities that you're bogged down with. But to say a normal day when we come in and when we know that we're looking forward to a really busy day is when you come into the office, there are of course people who are waiting for you. There are some existing clients, there are some new clients. So of course the existing clients get some priority because their matters are already there. They've already engaged us. So I think the first half of the day usually are in the courts because the matters are all listed. We are usually in the court. I mean, unfortunately, because of the COVID, all of this was completely disrupted, but a lot of things were happening through video conferencing. Many hearings and many applications were being heard, both here in the Bombay High Court as well as the Supreme Court. So a normal day would be the first half, at least till about 3 p.m. We are all busy going to the courts, addressing issues in the court, and then briefing certain counsels. That happens also in the court sometimes. And then when we come back, that is the time when we sit with the newer clients or the existing clients, debriefing as to what really happened. A large part of my life is into explaining the client as to what really transpired in the court. Because the common parlance, the common understanding of the client is not probably that equipped to understand what were the observations of the court. Is this good or bad? Most of the time, in cases of white collar crime, there's a lot of anxiety. There's a lot of insecurity, there's a lot of fear, there's a lot of, and the worst thing is a lot of multiple advices that the client always equipped. And today you have Google, which is like a lawyer, giving all the advices that they want. So every client is a lawyer, every client is well equipped, studies, reads and comes. So it's become more challenging. You have to be extremely calm, you have to be very, very patient, you have to understand what the client is going through, and he's being fed unnecessary information from all quarters. So that needs to be filtered down, boiled down, explain what can be done. Keep reinforcing your faith system that they have to build, they have to continuously keep maintaining the faith. And it is that faith in us that is what wins at the end of the day. And it is that faith that is the only power that leads us to do what we do. And so most of the time it's client interaction. First half of the day is going to the courts. Then the remaining day goes with the clients. And then towards the end of the day, we either go to the council's offices where we are briefing the senior councils, or we do an internal team meeting on taking a debriefing of what really good happened and what bad happened, and how can we learn from our mistakes daily. Very stressful, I must say that very clearly. I think the people who join us as interns and freshers must subscribe to the fact that the job in our office or in this industry per se, whether it's MZM or whether it's any other competitive office, is going to be extremely stressful. They must subscribe to the fact that it's not an easy assignment, it's not an easy job, it's very laborious, it requires a lot of going out, coming in, carrying papers, reading very stressful information, sometimes dealing with clients who have a lot of stressful information that they want to share. We put our associates and juniors through this exercise because it only makes them strong. It also gives them inculcate the habit of reading, a lot of local language reading. So a lot of Marathi reading is very important because all the FIRs and case study and paper documents are all usually in the local language, all states. So inculcating those habits to read, translate documents, prepare bail applications, read earlier made applications, and also do research work. So it's very, very stressful in a normal associate life. But the only associate that can shine and grow and become successful is the one who enjoys this. So that's the difference. The difference is that there are young, bright associates who come into the interview and say a lot of things that they can do, and then they can't handle stress. So we've gone off a couple of people like that. But then the ones who've stayed back with us are the ones who enjoy the stress, who enjoy the entire exercise of going through a very difficult patch of doing too many things together at one time, but at the same time enjoying the process, learning the process, working with clients, working with senior lawyers, working with humongous amount of voluminous documents, charge sheet, paper, forensic reports, audits, all of that. So all these things are the basic criteria that an associate or a junior associate must bear in mind, that they subscribe to this. So as I said in my earlier answer, we put the associates through the entire circle. So the idea is that we don't like to restrict in our firm as a policy to restrict them only to a mere draft or only to a mere briefing. We like to empower our clients because the senior partners, including myself, are always available to guide, advise, and rectify if there is a mistake. We enjoy this. I mean, that's how we've grown. We really enjoy. We like to give them a tightrope and ask them to walk. So in that process, there are some mistakes which are made, but then the senior partners, senior associates are always there to make sure that it is not at the expense of the client. Everything is verified and done by the senior partners beautifully. But the thing is that we like to put them in the fire, put them in the line, just to make sure that they can get through, because this is also a testing period. So it starts from drafting, it goes into briefing councils, it goes into preparing briefing notes, a lot of research, lot of what's happening in the subject in that particular domain, preparing us, briefing us. And then we've got a very interesting concept called the 530 Club, in which twice a week we pick one associate and we tell them to prepare a new subject, and then on that subject they have to address the entire office. That inculcates again the habit of preparation and presentation. So the 530 Club is an amazing exercise that we do. Even I attend it, and sometimes it's an amazing thing to learn so many new things, what the new interns come and prepare, and also the way they prepare it. So more than experience, it's an exposure. I think all the interns who have been associated with our firm have had a great time working with us, because it's very fascinating, of course, working with the associates and senior associates and looking at the kind of work they do. Interns have a very raw mind at the time when they are shuttling between the college study, academics, and then seeing it happen into reality in front of them. So we give them the exposure to go to the courts and see how the actual hearing is conducted, carry the papers, at times even brief the senior counsels, and experience the first-hand experience of the larger-than-life persona of a senior counsel sitting there while the interns are taking notes. We do not create a barrier wherein they can't talk to the clients or they can't meet the clients. I, for one, know that I've had certain interns present in the conference room at the time making notes when some really high-profile clients were there. It goes down excellent with those interns, motivates them. We always ensure that we provide that kind of encouragement and support to the interns so that they feel motivated in growth. But of course, for selfish reasons, if we realize that that intern really has that value they can add, and then that can translate into a stronger relationship for us in the future. But for the interns who come and join us, it's more of an exposure than an experience. Of course, the experience comes with the exposure. So we are an open book. We are an open floor. We have no barriers. I, for one, and the other partners would all sit together, eat together, discuss together, crack jokes together. There's no serious protocols. The idea is that that is what kids must enjoy. Globally, I think business models are changing. All the bureaucracy related to seniority and junior is no more there. Everyone comes with their bit of experience and they want to contribute. So we appreciate that and we enjoy it. It's a great experience for anybody, any intern who comes and works with us. I have personally interacted with them and they go back with an excellent experience. So as far as I am concerned, I think, my upbringing had a lot of role to play. I think my upbringing had a big role to play in my decision, because my father has been a criminal lawyer, still very actively practicing for about 48 years now as a criminal lawyer. So that influence was always there while I was growing. I had my doubts while I was a student, whether I want to be an appearing counsel or should I run a firm or should I join a firm. But few accidents here and there, a few hit and miss here and there, I decided I wanted to set up a law firm in 2005. But once I decided in 2005 I wanted to set up a law firm, the only expertise that I knew growing up, working with my dad and learning criminal law, was to develop a law firm which was specializing in criminal law. So in 2005, the mindset was criminal law, a designated law firm. We'll have lawyers who will come and work under one roof, and we will do criminal work. As time went by, a couple of years here and there, we started realizing the magnitude of the offenses that were happening. EOW was very active, the economic offenses wing. The pecuniary jurisdiction was moving constantly. I remember at one time the pecuniary jurisdiction in my practice earlier was 50 lakhs to be attracted to go to EOW. And then it came to 1 crore, then 2 crores, and now it's 5 crore plus. So that speaks volumes of the fact that how the magnitude of offenses were changing, complexity of economic offenses were growing. Media was starting to play a very important role. Around 2010-11, suddenly white-collar crime, criminal lawyers became very glamorous. It became a very, very glamorous subject for students to come and join. So I think it's an evolution process. It just happened. There's no strategic planning. But I can tell you one thing for sure, that I was very certain when I set up the firm that this would be a center of practitioners who will come together specializing in criminal law. And now I can say that we have specialized and mastered in white-collar crime and business crime. It's a very high-power, high-pressure job. It keeps you on your toes all the time. I think as much as there are days when I hate it, because when I'm seeing the kind of pressure that you're in, your phone calls are up till about 11:30, 12 in the night. Your day starts at 7 in the morning. There are a lot of expectations, huge pressure, but it's extremely glamorous. It's extremely fulfilling. To get victory for a complicated case and a complicated case for a client I cannot even express the sweetness of that success. But what I enjoy thoroughly is a great team to put together, work on a complicated matter, which involves a lot of documentation, a lot of paperwork, a lot of challenges. Time and again, you have to demonstrate a lot of strength, integrity. You are tested on your integrity repeatedly. It's there are tests on a daily basis, and once you come out of it, that victory is just most beautiful. I think that has led us to keep being addicted to this industry more and more.